This High Court case, which is costing Chrissy hundreds of thousands, is going to be a case study for us, so that we can see where do things go wrong. It's very easy to mislead both the public and the councillors because we don't have the technical knowledge.
We are not working on their case, but when the first respondent files an affidavit, we have a responsibility to peruse the affidavit filed by them. Perusing the affidavit does not mean that we are working on their case. We are not drafting the affidavits. They have their own sets of attorneys, their own counsel. The work that they refer to is the work that we did in order to present outline, which is reading documents filed by the first respondent, perusing documents filed by the applicant in response to the answering affidavit filed by the first respondent, and I am going to be perjuring myself now, but I don't recall that we filed any response to the first respondent's affidavit. The only documentation and the work that they refer to is the perusal of the affidavits filed by the first respondent, the heads of argument filed by the first respondent, the applicant's reply to the first respondent's answering affidavit. Documents that we cannot go to court without having considered. Because should the city have been required to answer any of those affidavits, then it would have been negligent of our attorneys not to have perused and considered those affidavits. The judge does not exclude those costs. The judge gave costs. Costs include all reasonable and necessary costs. And you yourself, having been in a taxing master, knows that you cannot appear in court without having perused all the documents that are filed on record. You would be negligent in your duty to your client, and the court would certainly have a lot to say about that. So there was also a lengthy cost argument made. The judge actually found that the applicants unnecessarily dragged the city into this application, and if you read, I'll refer you to paragraph 121, and paragraph 121, he says, by the time the city sent out its answering affidavit papers, the applicant should have reconsidered their position. While I'm sympathetic to the applicant, I found myself unable to justify withholding costs from the city, and the result, the city will be awarded its costs, including the cost of 2 counsel.
There was nothing at sub-council level.
Nothing, never. This case, this application never came to sub-council.
I suppose there was complaints, so it had to come to sub-council.
Yeah. Yes, but they justified, the way the officials justified it, why they didn't have to come to sub-council, is because of this fraudulent document where the neighbours were initially asked for consent for certain minor departures, which they gave. Okay? Then a different plan is now being submitted with the consent. So they said, no, Because an item does not have to go to sub-council even if there's departures, if there's no objections from the So the permission from the neighbours were obtained in a fraudulent way. The plans that they submitted that they did not object to were not the same ones that had been built. If you look at the plans that the neighbours had consented to, and you look what's on the ground there now, it's totally different.
Basically, it was a dispute concerning various infringements by the first respondent on the applicant, and after the applicant had already, after the first respondent had already built the premises, the applicant brought this application. There's various references by the court also made to the fact that the applicant waited almost 18 months before instituting this application, where review application should be brought within 80 days. So at the end of the day, that is the crux of the matter. It is basically a neighbour's dispute.
If someone says to us, but there's a rider plan, we accept it's a rider plan. Only 2 years later do I, as a councillor, find out by a different official who's now in that position, Peter Kukumur, that there is no such thing as a rider plan. The minute a plan is amended, they have to go back to the neighbours and get new consent. But we didn't know that. We were just told this is a rider plan.
We cannot go to court without reading papers that are filed by the second, or in this case, the first respondent.
And we can't understand, why does the city, in the case where they were already unhelpful, where their negligence or errors had caused this dispute to go as far as the High Court, why does the city then go and become a party to this dispute between the two neighbours? And we can't understand that. I can say, sorry, we're not a party to this, we deny the contents of your affidavit, and that's it. They don't have to actually go and defend.
It is also reasonable and necessary that any response filed by the applicant to this first respondent's papers be perused by the second respondent. The second respondent's counsel and attorney cannot enter the court, and when confronted by the judge, throw their hands up in the air and say, oh, we did not read it because it's only relevant to the second respondent.
There was an allegation that the applicant made all the way through her papers that first respondent and second respondent were working in cahoots to get plans through the City of Cape Town that they were not entitled to. All the way along, her client, City of Cape Town, said, no, we're on our own steam, we're running our own case, we've got nothing to do with Mr. Bradbury, the neighbour, doing our own thing, he's liable for whatever he does, we will make our own decision. So now, for them to come and say that every single attendance that they undertook or performed or attended to that related to him, that they must now claim, it's an irony to me, the most ultimate irony ever. So I cannot see how they can have their cake and eat it. If they said, we're for ourselves, acting for ourselves, acting for our own interest, then sort your own case out. Go and do whatever you have to represent your own case. But don't involve yourself in charging the applicant for the costs that don't relate to you. The judge never said in his order that they can claim all the costs that related to them working on first respondent's case. And this is the point, once again. My client, applicant, said all along that first and second respondent were in cahoots, which is true, because the evidence showed that they were. And just the fact that they're trying to claim those costs now ticks that box exactly. Otherwise, what they must do is they must go and withdraw it again or take it off. I can't see how you should not, with respect, not take into account what your learned brother, Mr. Bazana, said. Your brother, as I said, made the decision already, and here's a copy of his letter, saying specifically, today I refer to the email below and advise that on the 15th of June 2017, when this matter was set down, and after arguments by both parties, I made a ruling that the second respondent cannot claim costs against the applicant emanating from exchange of pleadings and or correspondence between first and second respondent. Then, what they did, as a consequence, the legal representative of the second respondent decided to withdraw the bill of costs, and they indicated that it would take further steps in open court to remedy the situation, which they didn't do. They went and they threatened. I still remember I had a telephone call from Mr. Rian Meintjes, who threatened to go to court to get a declarator from Judge Bozalek as to whether in his cost order he intended that every single attendance that the second respondent undertook in regards to reading this individual's papers, meeting with his lawyers, chatting with his lawyers, sending correspondence to his lawyers, perusing the legal documents and court pleadings from his lawyers were claimable by the city. But he didn't do that. All they did was they re-enrolled the application for taxation, and it's never gone further than this. So for my learned colleague to say and to assume and to make a decision on her own without Bozalek, Judge Bozalek actually saying what he intended by that order, I don't know how she can usurp the authority of the High Court judge, number one. Number two, your brother already made a decision on this. So I can't see why we're arguing this point again. It is what I'm saying it is. They're not entitled to this. They can do everything they want to where they were working on their own case. But they can't do anything where they were working on the case or looking at the papers of Mr. Bradbury, the neighbor, the first responder. Your brother made this ruling already. I can't see how we need to discuss this any further. I just want to make a note that we'll serve the new 1441 on the 4th of June.
You can serve it in my office if you want to do that.
Fine.
Email that Hugo van Heerden has sent my attorney hounding me for payment. I am not going to pay the city 1 cent. I have informed the city I will not pay them 1 cent for corruption and lies. I will go to jail. I am not paying them 1 cent. You tell me. I've been to the cops. I've been to the public protector. It's with the police ombudsman. It's with the National Prosecuting Authority since 2016. Where does anyone in this town get justice against the might of the city of Cape Town? 2 mayors, Mayor DeLille, Mayor Plato. Nothing. The DA have done nothing for me. I was assured by Ozzy Gonzalez on the 24th of June 2013, before I launched my application, that officials are not permitted to give authority to build without approved plans, unless there is a dangerous situation on site that necessitates this, but under the supervision of an engineer and architect. Earth 58 has no approved engineer drawing, not one drawing on record.
When was the wall put up?
It was put up in 2013. We don't have the detail of the retaining wall plans.
Can you get that quick?
Thank you.
And that is Kemsway.
That's correct, yeah. The only engineer certificate we've got is dated the 5th of July 2013.
Okay, that is the guest storage area. It is the latest plan, 2013, right? Then we take this one.
No, it should have been built to a plan dated in 2012.
Yes, this
Yeah.
is internal alterations, this one.
Sorry, I'm
Also-
blind as a bat.
That is also 2013. And then we go to 2012.
But this is internal, this is dwelling, this is
Yes.
gas storage. No, this isn't what I want. What I want is okay, we've basically got a boundary wall here.
Yes.
We've got a boundary wall here. There's a massive excavated courtyard here, right, which is Earth 58.
Yes.
There's a retaining wall all along here and here, right?
Okay.
And this is Earth 54, and I am Earth 57.
They say that I spoke to the senior building inspector now. He said the retaining wall is on the plan.
No, it's not on the plan. There's no retaining wall
Is that
on the
Mr.
Lord's
Wilkinson?
Fisher.
No,
He's a
the
senior building
retaining walls are not on the plan.
Because I just asked him now about the
No,
retaining wall.
it's not. Okay, it isn't. Okay, so that's a lie.
Let me just check here
Okay.
quickly.
So the fact is, when you have an engineering's retaining wall, okay, there is a proper engineering plan, okay, that shows the retaining walls.
Yes.
We've got these plans that you've said here.
I just want
okay?
to check something in dams
But
quickly
yeah.
before I do say
I
anything.
mean, this is totally not. You know, I mean, it's nothing to do with a court
I've
case.
checked the files. I've checked. I know number 12 Victoria Road.
Yeah.
I checked the files. I checked the
Can I
plans.
have a look at the files?
It's all by legal services.
The whole
Seriously,
files
we
are
just
by
phoned
legal.
now Rousseau, Mr. Rousseau, in legal department.
Okay.
And they're sitting with everything.
Okay. We believe there are no engineer's plans. We've seen nothing, and I've been through all the files, unless
Yeah.
there's something new. Okay. My attorney called the engineer, who's
Yes.
has to call the owner, right,
Okay.
before he can come and talk to us. The retaining walls on the boundary
Okay.
are all we want, and that the courtyard is, and the engineer certificate from the courtyard. That is not an unreasonable request. Okay. I don't care about the plans of the house, the inside of the house. All the things we're complaining about, I don't care about that. I need to know it's structurally safe. That is a reasonable
right.
request.
No,
Okay,
you're quite right.
and I know the reason they're hiding this is because they don't exist, and it's just not fair. I want to be able to sleep at night, or else this becomes a very serious matter.
I'm not telling lies to you.
No, I know, and I'm not blaming
Yes.
you.
No,
Okay,
I'm just
please keep
trying
that.
to assist you.
And I was told by Chris Coetzee today I could come and have a look at the. In fact, he gave me an email saying I could see all of this.
There's a new case number. There's a new case number. So what they say here is issue. Oh, what is this? There's no documents here. No documents here.
There's no documents, but
And
they're
it's going
saying.
into LUMS land use application.
So this is something that's going in now.
CF number 58. Nothing.
There's nothing in there, but they're saying something's opened. This is very
No, they've
suspicious.
just cleared it all out.
They've cleared it all out.
It's in land use application. 58. 4. Nothing.
There's nothing there. This is.
It's like they've been wiped. That's all.
They've been wiped.
Yeah, I'm sure.
Is there any way am I allowed to take photographs of this or not?
No, you cannot.
I can't take photographs.
Can cause my job.
Yeah.
No, okay.
I just tried to assist.
No. I know you did, and I don't want to cost your
We
job.
can go to. Where's
But
the
it
other
just
one?
seems- so
You can check this
basically-
one quickly.
Yeah.
I can't see anything.
So,
That's all he's
There's
saying.
case numbers, but there's nothing.
but there's nothing in it.
So
Is that unusual?
No, it's not. It is unusual.
otherwise, I'm going to end up in court. I'd rather say nothing.
No,
Nothing.
it's best to say. But is that not bizarre? It's bizarre, isn't it?
Yes. You know, even the building inspector's copies is gone.
I know.
I looked in that room now.
Sure.
They have their own copies and it's gone.
It's weird.
And Steve Wilkinson is the building inspector.
Yeah.
Let's check this one here. This one here. And that is this one. That one.
And there's nothing.
Operations and operations and operations. Who's the case officer here? Who's the CN lumps?
Can you tell on this system whether they had a heritage permit or a demolition permit? Do you know? How would I find that out?
Okay, this 3 we can cut it out there. I can find.
So basically 138412, 313 2013, 1556 2013 is not there. And tell me, and there are no other plans that you can see. And basically,
there is
what plans?
2009.
But that's the 2009
It's dwelling
is
extension.
01809 and 2012 is 013.
And there
Three.
is-
What was that? 013.
sorry.
What was that? 01384 2012.
This is this one.
Yeah.
That's that one.
Then there's a 003, 003132013,
is this one.
which is internal dwellings.
Yeah.
So that's dwelling extension, internal. Okay, let's go up. No, I don't want the internal. I want the external. The garage, the dwelling extension adds to house.
Look at this
01809 2009 08138 1996 07007 1993. They're all for additions to house dwelling extension.
Yeah.
There's nothing that says
It's,
boundary wall or
when did it go
retaining wall. It went up in 2013, 2012 to 2013.
Nothing.
Nothing.
I think that
I mean,
case,
I've got all the dates.
I think that case is about that.
Yes.
Because I think maybe you're not the only ones.
No. We're the only ones.
Are you
Okay.
the only ones?
The case is that he had a set of plans that we signed an agreement to.
Okay.
He then put in another set of plans.
Did you see the plan for the
Yeah. We let me just tell you what he had a set of
He's
plans.
asking if you saw one for retaining wall.
No, never. We've asked.
You
There's
didn't sign
never
it, never saw
nothing. We signed nothing.
They fiddled with it.
And I wrote an email yesterday to Mr. Schnackenberg, right? And I said to him, I said, where are the... I said, this is serious. Very serious.
Why don't you make an appointment with Fiona Hugo?
With who?
Fiona Hugo. 16
But I don't think she cares. I understand they have to defend these people. I understand they have to defend the people who
How
work
can
there.
they defend if
But
there's
this
something
is-
illegal?
But
I know, but if
But it's
someone's
not just that it's
involved or
illegal.
they know, then they don't want to be found out, sort of thing.
But also, it's unsafe. My house is a meter away.
Why don't you make an appointment with Steve Wilkinson, building inspector?
Steve Wilkinson is under investigation with a public protector. Okay?
So here's an application in the system, okay? That's the case ID over there, okay? This case was created on the 27th of March 2017. They need to demonstrate compliance, basically, for this application, right? Which was submitted in March.
Which was BDMK
Created in March, I should
703-44024. Okay,
What was
so...
that for, that application?
Yeah.
What exactly did it entail?
It's for a dwelling extension. This is all submitted via portal online.
He's got something going on.
It's a wall, proposed wall.
The boundary wall common to my boundary, which has already been built as a retaining wall. And there's a basement. We need to know, has he put that on a plan anywhere, that it's so deep, that it's been excavated so deeply? On the base, is that the basement plan?
This is the site plan.
Yeah.
Okay. Then we have some 3D drawings.
Can you just go up? You see that wall here? This wall, that one, there's no planning permission for that. That's on my property. That's also a retaining wall. And there are no approved drawings on the 2010 approved plan, the 2012 approved plan, or the 2013 approved plan. Is he applying to have that wall? That one, yeah. Is he applying for that?
He's showing it as existing.
He's showing it as existing, but it's not existing.
But it exists, but it was never.
It's not approved, yeah. And also, you see this wall here? This wall is not on any approved plan. That joins the swimming pool to the main dwelling. You see? So they're both fixed to the main dwelling. Now, on 2010-12, there's no retaining wall here. There's nothing. So I mean, that wall is showing as existing. This is already. It was built in 2012.
Okay.
Yeah. And what I've got is I've actually got. This might actually make your life easier because I've got photographs of it, of the build. Which is why I wanted to meet with a loons guy. You see the wall there, the swimming pool wall. There is a very large steel structure covered in astroturf.
Okay.
Which also I see is not on that drawing.
This wall he's putting up is 2.1 meters high.
Yes.
Which is higher than standard, which is 1.8, I think.
I do know of a policy.
Policy.
Yeah, the policy.
Okay.
Yeah.
But it's
Boundary wall
yeah.
policy. And as far as I know, 1.8 on the street high, and I think 2.1 on the lateral boundary.
But here you go. You see, there's the wall. There's the bottom structure.
That's on site, eh?
That's actually on site.
Current or what?
No. This was built in 2012. The whole thing was completed in 2013 with an occupancy certificate. So that was then concrete cast, and that was concrete cast joined to the wall. And here there's a window in the wall, which joins the basement to the swimming pool. So it makes it part of the dwelling. This is in the basement area. It goes down. Now here is the top level. Now this was supposed to be a planter, which was reinforced concrete, and it's brick. And there's supposed to be a 500 mil gap between the garage and my boundary wall, which is a vibratite wall. But they lay a retaining wall underneath the garage, behind the garage wall, which isn't on any plan. And it's certainly, so is it any of that on this plan?
On these drawings?
Yeah.
Well, let's see what they've
That's
got,
what we're
you know?
looking for.
This is the proposal.
So they're just showing what they consider to be new stuff.
Yes.
Are you allowed to talk about
So he's actually putting a new fence.
It says a proposed fence, yeah. Proposed timber fence, yeah. It says that there.
But how can it be straight if there's a kink at the end there?
There.
No, the left-hand side. There's a kink that goes in. It's a vibratite wall. That's where my vibratite wall is. How can it be a straight fence? Have you got the engineer's drawings to hand?
Let's have a look. I don't see any engineering drawings.
Now, does it say in the 2010 plan that it's a new dwelling, or is it still saying additions and...
Let's try and find the 20. There's no 2010 plan.
Now, everything here, the 2012 plans, the 2013 plans, which are the only planning approval, and this one, which you don't even have on the system, they all say internal alterations dwelling extension when it was a new building. Why would that be? Do you know?
It's such a long time ago.
No, but come on. Should it have not have said new? What would it normally say?
I'll have to have a look at it first.
Okay. It's just that every time we come here, I have to pay these men, and I'm not getting the answers I want.
So what do you want?
I want to know why due procedure hasn't been followed. There were no, like for example, 2010, no demolition permit, no heritage permit, nothing. Okay, I've got here. So that's common clause. So why is this man being allowed to get away with retrospective planning, and why did he get an occupancy certificate on a building that's not built to an approved plan, when I have been saying this for years, and the on-site reality is that it isn't built to an approved plan? So where do I get my justice? That's all I'm saying.
Okay, so the question is, what is the procedure to follow to obviously answer your questions? That's, I think, is the question.
Yeah, because the city are saying, they just say, like for example, I've got many emails from Peter Kukemer and Ozzy Gonzalez saying it's built to an approved plan, where quite obviously it isn't. Okay. Now, Richard can tell you the swimming pool issue, just as one instance. There are many. And also, like for example, the retaining wall to my property has already been built. It stands.
But there's no drawing for it.
But there's no drawing for it.
No
there's
approved
nothing.
drawing.
Again, I ask.
Well, I have.
So what? Okay, so I think you're going to answer your own question. So what is the procedure we need to follow to determine
Whether they did it appropriately or not.
Yeah.
And that's the big question mark.
Okay.
So what do we do then? How do we...
We'll have to find out.
I was told the plans are approved and they wouldn't get occupation until it was approved, so I went to court to put the plans aside. This is really criminal.
Look,
And I want to know, really importantly, this Loffelstein in structure that's on these plans, where is the engineer drawing and where's the approved plan?
this application is obviously not approved. It's still
I understand, but the fact is,
Okay.
I want you to show me on the computer Go through all the plans and tell me where the engineer drawing is for this Loffelstein build
So we
retaining
went
structure.
through the case. There wasn't any engineering drawings.
No.
Okay, could we go to the second one? So we had the first one was 2009,
Yeah, let's go to 2012.
and then we had the 2012 drawings, also paper.
Okay, so let's make a record of this for the voice recording. Is that there only are paper plans, and we've got the paper plans, and the paper plans say that is not built to an approved drawing. 2013, can we have a look at those?
Same story.
Nothing on the system. What a tangled web we weave. Okay, so that's that. So, and then let's go to the latest application, because that application you showed us was March 2017. There was one on the 11th of May 2017.
What's this one?
Yes, that's the one we looked at, right?
That's the one we just looked at. Oh my
No,
goodness.
okay.
I thought it was the.
Sorry.
I thought we looked at the other one.
There's
two.
more, obviously.
Yeah.
So, this is something different again.
Can I just take a picture of that? Do you mind?
Sure.
Excuse me, Richard. I've got massive structural cracks, and that's why I've had to get an engineer, and it's caused by the excavation.
This is also there's no decision made yet.
Yeah, we know that.
What
It's
are they
with the plans
applying for here?
examiner.
Correct.
So what is this about?
So now,
Oh, there's that.
that's the lawful site.
Yeah.
It's gone.
So now, I don't know if you guys seen this form before.
No.
Okay, now obviously to get officially, you've got concerns. This is a step to follow.
No, but this has gone beyond that.
No, but have you actually filled one of these in?
No, but
And you've never been offered one either.
no, but let me just tell you something. This is why this is irrelevant. We went to the High Court with this structure.
Okay.
So that structure was built. A judge went on site to do an on-site inspection. The judge was misled into believing that was the 2012 plans. The building inspector's squiggles were on it, but there was no plan drawing. That's fraud. Okay, so if you can give me one of these forms, I'll gladly take it and do what you suggest.
Go through it.
I will.
Go through it, read it, and try and understand it, and then
Yeah.
perhaps what you
If
guys want.
we hadn't had a court case, because and also you see Jaco Theron, who was then the building development manager, wrote in his affidavit that all the illegal works had been demolished. That's illegal. It's not got planning approval. You know, I'm not expecting.
You're saying such a lot of things. It's like, wow.
I know, but it's
know?
not. You know, but I'm just making you understand. And you see that swimming pool, it's not legal. Is he applying to have that swimming pool?
On
built?
this application, it says existing pool.
Existing. So he's not applying for a new swimming pool build.
Where did you see this one?
It says existing pool. I know, but I'm just clarifying.
What he's applying for is this.
Yeah. The reason I'm clarifying it is because all of these things are being done in piecemeal. It's impossible to keep an eye on it. You know, this is what he did through the whole application. But this is absolutely criminal.
From my perspective, too, what worries me is that this wall here, on the engineer's drawing, it shows a concrete retaining wall. Photographic evidence says it's brick.
Okay, obviously all your details gets attached here. We create a case based on what you say. You get a reference number, okay? And you've obviously that your complaint needs to be concluded. So obviously you have a reference now, and then it becomes real.
Okay, but what I want to know is that form and whoever's looking at it, are they the same people that are making the approvals, or is there some oversight that's higher? Because it's very difficult to audit your own work.
That's why there's a reference number, okay? So it goes to the secretary, she does the administrative duties,
Right.
okay? And normally, depending on what the issues are, most of the time it's the building inspector who gets notified. And from there...
Okay, we've got that. Okay. Now, you see there's no courtyard here in 2013. So that's one plan, okay? Now, this is the second plan, which was just for the gas installation. Okay, so this was the gas... Now, this was 01556. It was 16th of September 2013. Now, You see, that's the drawing. Now look what he's done. For one thing, this, you see that drawing, you see the curve of the courtyard. Next to that is a stone gabion with no soil on it. That's a structure. That structure is not on that plan. That wall next to the grey area, is a brick wall which is 5 meters deep, at least, okay, which isn't structurally sound, number two, okay, which we've done in a report. That drawing is a fraud.
No, I'm not lying to you.
I'm not saying you are.
Speaking
You're not
the
listening
truth.
to me. You spoke the truth, exactly.
If a
But
person
people are
asks me
frightened
if they
too.
want to see this file or that plan,
Yeah.
I take it out, the people can view it.
But I am a
Yeah.
layman protecting my property and my rights.
I understand you.
I have spent over R1 million on court cases
understand
because the officials have lied in court record. Do you expect me to come here and be charming? But none of this is personal against you. I will get to the bottom of this. You know, I've had my life threatened. You know, people. I've got a bounty on my head of 150,000 rand. You think people like that should be working at the city? Do you? Don't make me angry, Nazim, because I'm already very angry.